Thank you very much, my lord and my lady. Coming back to issue 1, I just want to conclude with the following general propositions. The judge erred in his decision in holding that the top-down principle did apply because stop-loss policy in Napier and Hunter was materially different, and the inquiry which Napier and Hunter was actually undertaking was not the inquiry which is being undertaken in this particular case. That policy in that case, in Napier and Hunter, was concerned with a loss which was calculated at a single point of time. If you like, it was a unitary loss or a single loss, and it was not concerned with multiple losses occurring over a period of time. And as far as individual container losses are concerned, they will give rise to a right to indemnity on the date of the loss in accordance with general principles, and they will erode each insured or uninsured layer, as the case may be, in the chronological order in which they occur. And of course, any recovery which is made is to be applied to each indemnified loss to which the recovery relates. And the provisions relating to aggregate, limit, and date of occurrence really have no impact on that analysis. So that brings me to the second issue, which is the issue for which permission was granted in relation to the order in which the losses were sustained. And this was an issue which arises because of the judge's judgment, which you can see at paragraphs 104 to 107 of his judgment. Court Bundle, tab 8, page 111. It begins at 103, where the judge states that it's clear that the recovery pursuant to the Hanjin settlement was in respect of operating lease losses only. No compensation was paid in respect of finance lease losses. And then the judge refers to the fact that there were detailed spreadsheets maintained by Textainer and available to the claimants, which provide extensive details of each loss. The spreadsheets were not in evidence before me, and no attempt has been made by the claimants to identify which particular loss or group of losses occurred when. Instead, the claimants pointed to the fact that the Hanjin settlement was in respect of all operating lease losses, and they sought to rely upon a pragmatic assumption that losses in respect of finance leases would have occurred at the same time, or at least in proportion to the losses in respect of operating leases, with the result that I should proceed on the basis that all losses under both types of lease were suffered evenly between the date of the occurrence and 9th of March 2018, which is the last day on the loss schedule, so that's 18 months later. And the judge recognised in paragraph 105 that the assumption would make a material difference to who would benefit on the claimant's case. But in paragraph 106, the judge says, on the material before me, I do not consider to have enough information to make the assumption proposed. The Hanjin received and bankruptcy trustee may have a different interest in finance and operating leases respectively, and I do not know on the evidence provided whether it can be said with confidence that finance lease losses in this case track the profile of the operating lease losses. As the profile of operating lease losses has not been analysed in evidence, it's not known whether and to what extent significant numbers of such losses in fact occurred at the same time, or at the same time as finance lease losses, and as a result whether or not it can be determined which policy paid what amount in respect of which type of loss. And in paragraph 107, I agree with Textainer that it was for the claimants to establish the factual premise on which the claim is based. In my view, they have not done so. Now, we say the judge erred in a number of respects in that sense. First, it is true to say that there were detailed spreadsheets maintained by Textainer, and they did provide information in relation to the loss. And the spreadsheets were not in evidence before the court. As far as that is concerned, I'm sorry, my lord, I've gone out of order. I'm sorry. The first point I should make is this gives rise to an issue of fact. And I should have made it clear, I'm very sorry, that my learned friend and myself agreed that the principles set out in paragraphs 63 to 64 of my skeleton, dealing with appeals from issues of fact or decisions of fact, represent the relevant principles. So I should have made that clear. The point I was going to make is that this is a question of fact. I also submitted that this is a case where the court can lawfully draw an inference in accordance with the principles adopted in municipal mutual, which I'll come back to. But on either approach, whether it's a question of mixed law and fact or a question of fact, we'd suggest that the judge was plainly wrong. Now, there were spreadsheets itemizing each of the 113,000 individual container losses or more. The only evidence before the court was that the spreadsheets itemized the quantum of such losses, not the date of such losses. Had the individual losses been identified by date, then each individual loss would have been attributed to a particular loss policy layer. And the part of the reason for that, if we can go to the supplementary bundle, at tab 6, my learned friend cross-examined my instructing solicitor, Mr. Chatfield of Kennedy's, and you can see this at page 24 of the bundle. And at the bottom of page 122, the question is asked here. In relation to how the claims have been presented, just backtracking a little, the claims that my clients have presented to the program were presented as a whole, weren't they? And the answer is, when you say they were presented as a whole.
I beg your pardon, I haven't found the reference.
Oh, I'm sorry, it's page 24.
Yeah.
At the bottom of page 122.
Right. Oh, yes, I got that, thank you.
So I've just read out the question at the bottom of page 122, and I'm now proceeding with the answer at the top of page 123. When you say they were presented as a whole, can you please explain what you mean by that? And they had presented a lump sum claim for rental charges with a lump sum for repairs and a lump sum for repatriation. Well, we had got the schedules that show that, but obviously what they did was they submitted Excel spreadsheets breaking down every container, every loss against each container. But they didn't claim each container against any particular policy, did they? No, they lumped the claims in relation to each container and each element of the container into a total figure. And the total figure was claimed against the program as a whole. Yes, well, obviously with certain exceptions for the fifth excess layer. And the reason for that was a particular exclusion of loss in relation to the fifth excess layer. So the point which is being made is there's no indication whatsoever that the spreadsheet actually identified the relevant date for the losses. Moreover, the claim figure, which was presented by Textainer to Hanjin, which you'll see in the same bundle at tab 2, at page 6, sets out both the losses in relation to operating lease and financial or finance lease containers. And the interesting thing about them is, as regards rental fees, they're broken down by month. And they're very, I mean, the quantum of the rental fees differ by a degree of 8 million to operating leases to 11 million for finance leases. But as a pattern of incurring of loss, they're both reasonably regular, reasonably even, both roughly in the same amount for each month. There is no reason to assume, for example, that the finance lease containers losses were all suffered before the operating lease containers, because you can see it broken down here.
But that's only in relation to rent, which presumably Hanjin just didn't pay after.
There's still a loss which is recoverable under the policy.
Yes, but at that point relates to rent, doesn't it?
It is, but it's still a loss. So just because it's rental, it's a financial loss which is insured against.
Yes, but what I'm getting at is if you're trying to make a broader point about even distribution of losses, I'm not sure you can do that just from looking at.
Well,
looking at rent.
I agree. I think my lady's asking it because it's dealing with one type of loss rather than other types of loss.
But particularly a type that by its nature recurs.
Because rent is due.
Because rent is due.
That may be. I mean, it depends on. Well, it depends on a number of things. It depends on how much the lease is left. It depends on how much is owing under each lease. I mean, each lease may not have. I mean, for some of the leases may have expired a month after the date of occurrence, and some may have expired 6 months after the date of occurrence. But just as far as the loss of rent is concerned and nothing else, there is no reason to assume that the relevant losses in relation to that particular loss can't be said to have been suffered in relation to each type of container evenly and regularly over that relevant period of time. So the judge queried, for example, whether it might not be the case that all of the finance lease losses were incurred first and all of the operating lease losses were incurred second, or vice versa.
Well, I'm not sure I quite understand that. I mean, as you rightly point out, we can see rental fees are broken down month by month. But what on earth does that tell us about losses? Because how do we know when rental fees fell due and payable? It might have been payable month by month. It might have been payable at the end of the year, calculated on a monthly basis. It could have been done in some other way. I mean, one notice for example, the third asterisk, it says February 2017 rental figures are prorated at 57% of 4 months rental billing. And that seems to be completely neutral to me. That might suggest it's monthly billing, or it could be annual billing in respect of that month. So how does one know, just because a monthly breakdown is provided, when the loss is actually sustained?
Well, all we've got is this is a claim for the recovery of losses. It's identified rental fees forms one head of losses to which is the subject of the claim, and the rental fees are broken down by reference to month. Now, it's possible, I think what my lord is suggesting is it's possible they actually may not fall due for payment until a single date, whatever the date might be. Or it's possible that they each fell due at the end of each month, which I think is the more natural assumption. And therefore you do have losses occurring as and when the rents fall due. And remember, this is a loss to indemnify against loss of rent. And once the rent is not paid, the loss has been incurred and therefore a claim can be made. And there is no reason to just looking at rental fees and nothing else. I'm not trying to extrapolate to other fees just yet, at least. But in relation to rental fees, there's no reason to assume that these losses can't be said to have been suffered evenly and regularly during the relevant period, both in relation to operating lease containers and also finance lease containers. And it's true to say we don't know the details of the underlying leases, but I doubt we ever, at least the insurers, would ever know what those were. But that's by the by. That doesn't affect the assessment.
You can find out because you could get disclosure.
Well, my lord, in circumstances where there is said to be $100 million worth of losses, which exhaust the...
Yeah, but you could start by asking for one sample lease to be disclosed.
That's true. I don't dispute that, but that doesn't still... as far as this schedule is concerned, the schedule indicates that these are the rental fees which are unpaid at the end of each of these months. And all I'm suggesting is that reflects what the loss might be for each of those months. That's all. I'm not suggesting anything else.
Okay.
Effectively, as regards rental fees, you're saying there was some date-related
Correct.
evidence.
Correct.
That's what you're saying.
Yes, and to be fair, this is a schedule which I did draw the judge's attention to, which is not referred to in his reasoning in the paragraph I referred to. As far as recovery costs are concerned, what is said, we've got a total for recovery costs, which are in similar sums to the rental fees, which says we are, and the asterisk reveals we are unable to break out per unit expenses by month, as most units had multiple expenses that occurred in a time period greater than 1 month. Now that very note indicates that the relevant losses weren't suffered in terms of recovery expenses at any particular time, but were extended over a period of time. Now,
would you accept that phraseology suggests, and I put it no higher, that the administrator, the trustee, I apologise, the trustee had requested monthly breakdowns?
It might well have. I would put it no higher than that.
Yeah.
But my submission is, as far as the expenses are concerned, it's an indication that they weren't incurred at a particular point of time. They were incurred over an extended period of time. And a point I'm going to come back to is there's no reason to assume, when it comes to either rental fees or recovery costs, why the relevant costs should have been incurred earlier or later in relation to the operating lease containers than compared with the finance lease containers. The only difference between two types of containers is whether or not the Hanjin, if the lease has been performed, would have acquired title to the leases under the finance lease, whereas they wouldn't have acquired title in the operating leases. But nothing else about their circumstances, their value, their location in the evidence indicates that there's any reason to doubt or treat them separate, or to treat them separately as occurring at different times.
But for some reason, the trustee treated them differently, very differently.
And I don't understand that. I don't know. I don't know the reason for that. I don't know why they're approaching on this basis. That would be pure speculation on my part, if I hazard to guess.
May I ask this, in relation to the fifth excess layer, how did they calculate that part which was excluded from the cover, the fifth layer? Without any breakdown.
That was the difficulty with fifth excess is that they settled their dispute with the insured under a settlement agreement, which resulted in a payment of 25 out of the $30 million owing, which also had provisions dealing with waiver of subrogation and the like. And so it's impossible to go behind that agreement for the purposes of this appeal. So I don't know the answer to that question. Well, at least I can't answer it, I don't think. And of course, my clients in this appeal are not the insurers of the fifth excess.
Slightly reluctant to interrupt, but just in case it does assist, there is an explanation on page 23, and the maths have been set out there of the supplementary bundle. And I hope it's helpful to mention that now in case it assists my lord. It essentially, where the lost revenue claim that was claimed against the programme is assessed, the calculation is that the total lost revenue was 17.6 million, and 55 over 85 of that was claimed against the programme because 55 over 85 is the first to fourth excess layers in the primary layer. So that's how the claim was presented, to exclude loss of earnings in the claim against the fifth layer.
So not on a chronological basis, but a proportionate basis.
But I would obviously make the point that the chronology the chronological order of the losses doesn't matter for the purposes of the payment of the insurance claims. It matters in relation to the recovery because the losses are so large. So if you don't mind, my lords and my lady, I'm going to come back to page 6 of the supplementary bundle, which is the schedule which we've been looking at. And if we could look at the unrecovered containers, which is by reference to the book value. And remember, the book value is the agreed value in the policy for the unrecovered containers. And again, it just says unrecovered containers as of 16th of February 2017. So all we have here is, all we know is that these are the containers which were not recovered by a certain date. But if you remember, these are total losses. So if you remember, we tested whether a total loss has occurred under Section 57 or Section 60 of the Marine Insurance Act. Depends on the likelihood or unlikelihood of recovery or the impossibility of recovery. Now, it may be that the loss was incurred in December or January or February, and if the loss occurred in December, January, February, it would still remain lost at this date. But it doesn't mean the losses weren't incurred before that date, because it's a factual issue in each case whether the losses were occurred. So as far as the shed...
I may be asking a completely irrelevant question.
No, you're not.
But so far as unrecovered containers are concerned, I mean, why is that not the date of bankruptcy? I mean, obviously we've got no evidence as to Korean bankruptcy law, but one might have thought that that would be the relevant date, because that's the date at which title will pass to the trustee in bankruptcy, so that he can realise those assets for the benefit of the creditors.
Well, these are assets belonging to Textainer. These are containers belonging to Textainer.
Yeah. Okay. Sorry. That is a stupid question. Okay,
Well,
thank you.
actually not necessarily, because one of the reasons the finance leases might have been distinguished is they might have been treated as Hanjin's assets under
Only if
Korean law.
only if all monies have been paid under finance leases.
Well, no, but that you're making an assumption about Korean law, I think, because those assets would be.
Well,
on
there's
the
no
balance sheet.
evidence of Korean law being at
No.
odds.
Okay, but you're making, but we're all speculating, aren't we? It could have been the date of.
No, I don't think so. I mean, with respect, I don't think it is for this reason. And I'm not submitting that any comment made by my lord is, it was wrong. I mean, it was wrong, but I don't think it was, to use your phrase, stupid. I don't say that. But what I do say is this, that the only thing that happened on the 31st of August 2016 is Hanjin petitioned the sole court in relation to its insolvency. That's the only thing that happened. The question whether the containers were lost, and remember these containers were in depots around the world or on ships, is whether or not they could be recovered by Textainer. So even though they may be insolvent, it's still some of the containers, and in fact many containers, were recovered.
Well, fine, but that takes us back to the questions we were asking, which is that this claim is predicated upon the relevant date being the 16th of February.
No, the claim identifies the containers which remain unrecovered as that date.
Right.
So the loss may have
But
materialized.
it's not an arbitrary date. It's the date of the bankruptcy, isn't it?
No. Oh, so it's a bigger pardon. It's a date on which the bankruptcy was ordered by the sole court.
Exactly.
I'm sorry. I thought you were going back to the 31st of August.
No.
No, it's my fault. I'm sorry.
Right. So I come back to the question which I was asking, which is, this is not looking, certainly so far as recovery costs and unrecovered containers are concerned, it's not looking at losses as at 31st of August 2016. It's looking at losses as at 16th February 2017. And that has to be because that's the bankruptcy date.
Yes. And what follows from that, may I ask, my lord?
Well, I'm not sure that anything necessarily follows from it,
No.
but certainly it does suggest that those who were making the claim thought that that was the relevant date for the purposes of assessing their losses.
Well, that doesn't. Whatever the claimant may have thought for the purpose of assessing their losses, and remember this is a claim being presented to Hanjin,
To the trustee in bankruptcy, to be sure.
it doesn't mean it's not a loss at an earlier date for the purposes of the insurance policy. Because even though it may be the date of the bankruptcy as ordered by the court, the question whether the containers were lost was whether or not they were unlikely to be recovered at the very least.
Now, I can understand that your point that the question of date of loss under the insurance policy is a different question. But of course, we're looking here at recoveries.
Correct.
And thinking about it from the perspective of recoveries, here we have Textainer presenting a claim which, to the extent that it is accepted, will be a recovery. And Textainer, at any rate, certainly vis-a-vis the trustee in bankruptcy, seems to be proceeding upon the basis that the operative date is the 16th of February.
Okay.
And as we were discussing earlier, there seems to be no evidence which sheds any light on why that is, save for the agreed fact that that's the date of the bankruptcy.
I think my learned friend wishes to say something.
My lord, again, I'm reluctant to interrupt, but there was evidence before the judge, which is not in the bundle, which was the letter from the trustee. And the trustee specifically asked for the loss to be assessed as at that date.
Right.
So I wouldn't want my lord to be proceeding on a false assumption that this was something that Textainer decided. I've got a copy of the letter. I can make it available for tomorrow. I've only got one for myself. And the judge
Your
refers to it.
explanation is
Indeed,
clear enough.
he gives that is referred to in his judgment. But it was the trustee in bankruptcy said, assess everything as at that date.
My point is that however Textainer and Hangen either formulated the request for the presentation of the claim or formally presented the claim is irrelevant to whether or not there was an indemnifiable loss under the policy. The question whether there was indemnifiable loss under the policy is whether or not the containers were unrecovered without any likelihood of recovery. And that may well have been before the February of 2017.
But this is the point, isn't it? One's got no idea.
Yeah.
All we can see from this document, and what Mr. Smith tells us rather confirms it, is that this is a document passing between Textainer and the trustee in bankruptcy, with a view to Textainer's claim against the trustee in bankruptcy. And for all one knows, looking at this document, taking the unrecovered containers by way of example, they could all be lost on the same date or treated as having been lost on the same date.
Well, they could, but it's highly unlikely, I would submit.
How does one know?
Because we're talking, my lord, well, I'll come back to it, but there are 113,000 containers. 80% of the losses, sorry, 2/3 of the losses relate to total loss containers. As a matter of, I would say, common sense and logic, if you've got so many different containers, so many around the world, located in different places.
But that's with respect to different submission. It's one thing to say that it's inherently probable that containers will be lost on different dates. It's another thing to submit, which is what I understood you to be submitting, that this document is evidence of that.
Well, the reason, well, you're quite right about the first point. As to regards to the second point, all I was suggesting in relation to this document are three things. If I could just encapsulate that. As far as rental fees are concerned, it is evidence that the rental fees fell due and therefore constitute losses at, on a regular, even basis during the relevant 6-month period per month in relation to each type of container. As regards recovery costs are concerned, the footnote indicates that these were costs which were incurred, again, over time in relation to both types of container. And as far as unrecovered containers are concerned, all we know from this document and nothing more is what the book value of the containers which had not yet been recovered as at the particular date. And so that's what the schedule shows. And then I would add to that, it's inherently improbable, to use my lord's suggested language, that when you have so many containers in different circumstances, that the losses would have all been incurred at a single point of time, as opposed to asking oneself the question, when were they unlikely to be recovered?
Is that really right? Because the factor here, the unifying factor for all these containers, is that the entity in possession and control of them had become bankrupt. And it may well be that whoever it was who was assessing their likely recoverability might well have undertaken a blanket exercise and said, right, as of this date, I am going to say that the majority or X% of these containers are now deemed not likely to be recovered.
But there's no evidence of that, my lord. I mean,
No evidence to the contrary.
no, but when you have a situation such as this is where I say you can fall back on the inference, which I'll come back to. But what we do know is that for both types of container, the same treatment is given. And remember, the reason I'm dealing with this point is as follows. If I'm correct on my first submission, which is a top-down principle does not apply, it becomes important to identify which insured or uninsured layer dealt with, if you like, the operating lease containers for which the recovery was made, remembering that the finance lease containers were not the subject of any recovery. So the point the judge made was, I'm not in a position to know, for example, that the finance lease losses actually occurred first, followed by the operating lease losses. Now, if that was right, as a matter of fact, then of course the likelihood is that the finance lease container losses occupied the lower layers, which my clients are insuring, and the operating lease losses, which attracted the recovery, occupied the higher layers. But I'd say that that's an assumption. That's a possibility, which is incredibly unlikely, and there is no basis upon which to draw that conclusion, for two reasons. There's nothing in the circumstances of either container where such a distinction is even conceivable. But the second is, if one looks at this schedule, both types of containers, I should say, are dealt with in broadly the same way.
Well, they're dealt with broadly the same way by Textainer, but as my lady was pointing out a moment ago, not by the trustee in bankruptcy, because the trustee in bankruptcy thought that there was a key difference between the operating lease and finance lease. Now, there's no evidence as to what his reasoning was, but we do know that he differentiated between the two.
But my lord, any determination or decision, or even attitude adopted by the trustee in bankruptcy, is irrelevant to the question.
I'm not sure that's right, because you're effectively saying that the judge should have made an assumption about the way in which losses accrued in the order, if you like.
I do.
Raises a number of questions, but one is, are there any facts which might indicate a difference? You say that there should be a difference between finance leases and operating leases. Well, we know of one fact. We don't know the real explanation for it, but we know that the bankruptcy trustee was not accepting claims for assets subject to finance leases. Might that not indicate a real difference?
That explains why, whatever the reason is, that just explains that the trustee in bankruptcy did not consider that any compensation should be paid in relation to finance lease containers. It doesn't tell you whether or not and when rental charge losses occurred in relation to both types of container. It doesn't tell you when the inability to recover the containers, either type, occurred and when. And it doesn't tell you as and when the costs of recovery were incurred. It says nothing about that. All it tells you is on what basis the trustee in bankruptcy was prepared to offer compensation. And that could be for a myriad number of reasons. So I think I would go back to say that whatever decision or approach adopted by the trustee in bankruptcy is actually not relevant to the question at hand. The question at hand is a very simple one.
Maybe the record keeping in relation to the finance leases was different, and there was the trustee took the view that there was far greater prospect of recovery.
Sorry, my lord, could you repeat that question?
Maybe the record keeping internally at Hanjin was different in relation to the finance leases, and the trustee took the view that there was a far greater prospect of recovering them.
The trustee's not recovering them. It's Textainer who's trying to recover them from Hanjin.
Yes, but Hanjin may have felt it was in a far better position to
return
them.
If that was the case, we would have expected some sort of indication that there has been a recovery of those containers, because that would actually operate as a credit against any indemnity which has been paid. That would be a large, it's a large amount of, it's $18 million worth of the, or at least $32 million as far as the finance lease containers are concerned.
But we've got there's no evidence available in relation to precisely what containers were subsequently recovered, is there? And
We know, I think there is evidence about which containers were actually recovered up to a certain date. But that's not the issue. I think that's right. And my learned friend is nodding his head. The question is, what are the unrecovered containers? But there were containers recovered after this date. When one can, what I would like to, I've got so many thoughts coming out of my head, I just don't know which one to go for first. But when one considers the question at hand, was there any justification for the judge not adopting the pragmatic assumption which I was putting forward, which is, it's very, and I would call it a modest assumption, based on probability, is that the relevant losses of the finance lease containers and the operating lease containers would have occurred, whatever description, whether total losses, loss of rental charges, recovery costs, would have occurred regularly and evenly over that period of time. Moreover, there is nothing inherent, I would submit, in the nature of the two types of containers, which would suggest that it was more likely that all the finance lease containers would have suffered first, followed by all the operating lease containers. And indeed, for what it's worth, the way the schedule which has been prepared to support the claim brought against Hanjin by Textainer, although the numbers are different, adopts a comparable approach in relation to each type of.
Now, can I summarise in my own words the rationale that you put forward in support of that proposition?
Yes.
To see if I've understood it. And I think at the moment it consists of two elements. Firstly, you say it's inherently probable that losses would have occurred regularly and evenly over the period. Secondly, you say to the extent that there is any limited evidence which sheds any light on the question, it is consistent with inherent probability as opposed to being inconsistent. Have I got it correctly?
Yeah, can I add a third?
All right, what's the third?
The third is there's nothing in the distinction between finance lease losses and operating lease losses, which would detract from the pragmatic assumption I'm putting forward. There's no reason to assume, by virtue of their differences, which only relates to the terms of the lease, that losses relating to one would necessarily occur before losses relating to the other. Once the containers are lost, they're lost. It doesn't matter if on a finance lease basis or an operating lease basis. The cost which are incurred to recover them, again, is incurred, doesn't matter if it's finance lease loss container or operating lease container.
To be clear here, we're not talking about these containers magically disappearing or being crushed or whatever. We're talking about their traceability.
Yeah, but they're located all around the world. So there could be in jurisdictions where it's difficult to get hold of. There could be places where it's impossible to locate where they are. So everyone's potentially different. They may be in the possession of Hanjin or subject to a sublease. I just don't. I'm speculating.
There may be what in the retail world is called wastage. In other words, third-party theft or fourth or fifth-party theft in this case.
Correct. There are all sorts of possibilities. Remember, 113,000 containers we're talking about.
When you, this probably doesn't matter either, but when you say we should assume that they were lost evenly, in fact, if you start out at the beginning of this period, you don't know where any of them are. So in one sense, they're all...
In the same...
In one sense, they're all lost. So I just want to clarify how you're using the term loss there.
Lost
You
means
took us to the constructive total loss definition. Is it,
that.
you're assuming it's that? So some set of inquiries have been done and a view has been reached that container
Well,
probably can't be recovered.
yes, it's not a question of, I mean, the law is, it's a matter of fact whether or not it's
Yeah.
unlikely to be recovered. So not dependent on anyone's view. But yes is the answer. The question is, in relation to any particular container, whether or not it's unlikely to be recovered. That's the law. And the Marine Insurance Act clearly applies because the policy says so.
Thank you.
But the test of whether it's likely to be recovered is whether it may be a matter of fact. Somebody's got to perform that assessment, haven't they?
Well, normally it's the court if it's going to be an issue before the court. But other than that, everyone has their own view, and I suspect Textainer would only present a claim for a total loss if it felt that it was unlikely to be recovered. I think that must be right, but it doesn't mean it is or is not. That's one person's view. But Textainer is obviously in a better position than most to judge.
But to come back to my lady's question, why is it not inherently date dependent? Because at one date, it may be likely that a container will be recovered. At a later date, as more facts emerge, it may become unlikely.
Correct. But well, if what you're asking me is this, that you may have fewer total losses in September immediately after the 31st of August, and you may have more in October and more in November and more in December as facts emerge and which will inform you.
So as at the 1st of September, it may be the case, nobody has any idea
Correct.
because there's not enough information.
Correct. But what
It doesn't mean to say there's a loss.
or there's not. a
It
loss.
means that you don't know whether there's a loss or not.
Correct.
Whereas after investigation, you may be able to form a view.
Correct.
And here the view might have been formed as at the 16th of February.
Correct.
But
But
why is the loss not sustained then?
well, it may be, but it may be much earlier. All that schedule is saying is that these are containers which are unrecovered as at that date. It's not
But
saying
why is it inherently probable that losses will be sustained evenly and regularly over the period, when whether it's loss or not depends on the availability of information?
I think that's entirely right. May do, although, again, to complicate the matter further, the law is it has to be unlikely to be recovered based on the actual facts, whether or not those facts were known to the insured. But that's the law. But all I'm saying is, after a month, let's say it was 1st of October, which is a month after the application to the court by Hanjin, it may be obvious at that particular point that certain containers were located in unfriendly jurisdictions and therefore difficult to recover. And therefore, as a matter of assessment, as a matter of fact, they were unlikely to be recovered. And that's known.
And you could say, if that's the case, you could sort of read that back and say, actually, I've worked that out now.
Correct.
But you could say the total loss would have been at an earlier date. It
Correct.
might have been because of the nature of the jurisdiction. It was lost as soon as
Exactly.
they filed.
I think, my lady, that's my point. Unless you're telling me.
Okay, but then I suppose what I'm trying to understand, your point about losses arising evenly,
Well,
it seems more likely that it's
I certainly asked.
all or nothing, really.
No, it's not. I don't agree with that because the losses can emerge. The information.
But that's the information.
But the information may emerge. I suspect will emerge over time. So more information will emerge related to this. That's just to say containers
Why should
located.
information emerge regularly and evenly? On the contrary, the nature of information is such that it comes in fits and starts.
Sorry, I hadn't quite developed my thought. I'm sorry. But what I was trying to say was it may have been apparent early on that, for example, all the containers located in state X were going to be very difficult to recover. And then a month later, it may be discovered or maybe worked out that all the containers located in state Y are also very difficult to recover. The point I'm making is this, and this is happening depending upon the various circumstances associated with each container. But the key point for this purpose is not necessarily just that these losses were sustained evenly and regularly, but there's no reason to assume that the finance lease containers losses occurred before the operating lease containers. So you it may be an increasing number of losses going September, October, November, December, January, February, reaching a fever pitch, if you like, in February. But there's no reason to assume that that pattern wouldn't apply to both types of containers. That's the only point.
That's all you need to establish.
That's all
you
I need to
say.
establish.
You don't need to establish even rate, just whether one
Correct.
is faster than the other.
Correct. I can see the sort of pensive consideration being given to. I don't know if the question's about to come my way or not. No. Okay. Then what I would like to do is just look at the support given, for example, by the Court of Appeal in Municipal Mutual to this inference which I'm inviting the court to make. And that's referred to in the Authorities Bundle, tab 9. You can see the head note in the second column. It says, in 1985, the Port of Sunderland agreed that 2 excavators should be delivered to the port by sea. They arrived in May 1985 and were placed at 4 locations within the port area. In March 1987, an inspection found that there had been minor pilferage. In September 1988, the excavators were found to have been extensively damaged by theft and vandalism.
Sorry, can you explain to me how you place 2 excavators at 4 locations?
Well, I can only assume they'd be moved. Is that possible?
They're in lots of different pieces, my lord.
Okay.
It's apparent from later in the judgment.
All right, thank you.
There's cases with parts and a bit here and a bit there.
Okay, thank you.
So just it's the same column. The plaintiffs, Municipal Mutual, the port's liability insurers, made various payments to the port's lawyers and had financed 2 payments in the court. After judgment, the plaintiffs provided the sum necessary to satisfy that judgment, including interest and costs. The total amount of the physical loss and damage is valued at $3.1 million. In May 1992, the plaintiffs first notified the defendants, their reinsurers, that they were making a claim against them. The reinsurers disputed liability. The trial concerned 3 facultative reinsurance contracts placed by the plaintiffs with the defendants. Each was contained in or evidenced by a slip presented to the various reinsurers. And you will see in the next paragraph, each of the slips was in similar but not identical terms. And you'll see the period for the first was 12 months at 24th June 1986. So that's 1986 to 87. Then in the paragraph which follows, the second slip was for the same, except that the period was 12 months at 24th June 1987. And the third slip was the same, except that the period was 12 months at 24th June 1988. If I could pick it up at page 421. Sorry, not 421. 436. Sorry, 436, the Lord Justice Hobhouse. The entitlement to recover under the reinsurance contract. In order to recover, the plaintiffs must satisfy the court that there has been physical loss or damage which has occurred in the year covered by the relevant contract of reinsurance, which exceeds the excess applicable to that contract. Thus, for the contract for the first year, the plaintiffs must satisfy the court on the balance of probabilities that there was loss and damage which occurred during the 3 months between March 87 and June 87. So that's the last quarter of the first policy, which exceeded in the aggregate £500,000. For the second contract, they must prove that on the balance of probabilities during the 12-month period, June to 87 to June 88, loss or damage exceeding £500,000 occurred. And so the 12 months of that policy is relevant. And for the third contract, the plaintiffs must prove on the balance of probabilities that loss or damage occurred during the 3 months between 24th June and 25th September, which exceeded £1.5 million. Sorry. If the answer to any of these questions is no, then the plaintiffs have failed to show an entitlement to recover under that reinsurance contract. If the answer is yes, then the question arises what, on the balance of probabilities, was the amount of the loss or damage which occurred during the period. These questions are questions of fact. As far as the plaintiff's submission sought to treat them as questions of law, they were wrong to do so. As will be appreciated, the judge found the facts against the plaintiffs on the first and third contracts, and by implication found them in favour of the plaintiffs on the second contract. So the judge basically confined the losses within the second contract period. The facts must be taken from the judgment of Judge Stevenson. His finding was that no significant loss or damage had yet occurred at the time of Mr. Nolan's inspection. The goods had been disturbed, but there had been no loss. At the other end of the period, which Judge Stevenson identified, the inspection on September 25th, 1988, there was very extensive pilferage and damage, but there was still some pilferable items which had not yet been stolen. The inference we are invited to draw is that pilferage and vandalism had been continuing to occur right up to September 88, and was only brought to an end on the insistence of Concord and by the application of the port on 25th September 88, how serious the position was. I consider that the inference is justified and that on balance of probabilities, loss or damage was continuing to occur through into the period covered by the third contract. Indeed, it is to be inferred that thieves, having discovered a source of pilferable material, would not be letting up in their efforts to steal as much as they could. The goods had been stored out in the open at some 4 different locations. Some of the acts of theft must have required the use of cutting equipment, and the removal of some of the pieces of machinery, electric motors, must have required the use of the crane and the flatbed lorry. Apparently none of this was at the time noticed or remarked upon as being abnormal by the employees of the port. The judge estimated that a minimum of 300 man-hours of work would have been necessary to carry out the theft, and that unless the work were done by the same team of competent thieves, the working hours were likely to be considerably longer, particularly if done by night. There was a document dated July 28, 1987, when a port employee noticed a lot of bits off the crane parts lying about. The vandals are having a field day along there. Apparently some of the crane parts were moved to another site in the port in 1887, and there was evidence which suggested that a very substantial amount of damage had then been done to them. The evidence was thus somewhat sparse, but it supports the view that the loss and damage had already started before January 24th, 1987, and it was a continuing sequence of occurrences extending through the rest of 1987 and 88 to September of that year. I am unable to find that on the balance of probabilities, the loss and damage which occurred prior to 24th June 1987 exceeded in value the sum of £500,000. This was also the implicit finding of Waller J. It follows that the claim under the first contract of insurance must fail. Turning to the third contract, a similar answer can be given. Although there is evidence that justifies the inference that significant, probably substantial pilferage and vandalism was continuing to occur between June and September 88, it's impossible to say that on the balance of probabilities it exceeded the value, the sum of $1.5 million, which was the excess applicable. And then it continues, indeed, the balance of probabilities is that it did not. This leads to the second contract. This covered a 12-month period within which pilferage and vandalism was undoubtedly occurring. It probably started before the beginning of the period and continued through until after the completion of the period. The assessment of how much occurred during this period is very much a jury question upon which one has to make up one's mind, realizing that one's finding of fact is based on the balance of probabilities. On this basis, I'm prepared to find that the 2/3 in value of the loss and damage probably occurred during this 12-month period. That's because 3 months either side occurred outside the contract period. On a straight line basis, this would be the resultant fraction. It is clearly possible that not as much as 1/6 of the loss of damage occurred prior to June 87. There is no basis on the evidence for assuming an accelerated level of theft. It follows that a fair assessment of the fraction which probably occurred in the contract year 87 to 88 is 2/3, and I so find. And so Lord Justice Hobhouse recognised that it was probable that separate acts of pilferage which occurred over that 18-month period, only 2/3 of which occurred during the second contract period. Now, this decision was considered by the editors of Arnold on Marine Insurance.
Sorry, just before we go on,
Of course.
although this is a decision of the Court of Appeal, this is a decision on application to the facts.
Of course it is, yes.
I'm not quite sure why. There's probably a good reason why the Court of Appeal are doing that. They disagreeing with the judge?
Yes, because they're entitled to, of course. And all it has to demonstrate is that the judge was plainly wrong. I mean, this was early days. I mean, all the authorities I've referred to in my skeleton as to how the Court of Appeal treats questions of fact, which I say apply here. Obviously, most of those come afterwards, but still.
But you're not suggesting that this is laying down any principle. It's just
No, but I'm saying there's an inference available to the court based on what's inherently probable or improbable. And if one looks, therefore, at paragraph, so going back to the evidences of Arnold to tab 15, page 241. This is paragraph 3325. So the editors of Arnold say the amount recoverable under a contract of insurance may depend upon the order and amount in which the individual losses erode the available insurance cover. If the date of each loss can be clearly determined, losses are generally treated as having occurred in chronological order and allocated to cover in that order, although this must ultimately be a matter of construction of the relevant insurance and reinsurance contracts. It's not generally open to the reinsured to manipulate the order in which the claims are presented and allocated to cover so as to maximize the recovery. And then there's a discussion of Teal against W.R. Berkeley, which I've taken my lords and my lady to. And then if I could pick it up at the bottom of the page where it says by contrast. By contrast, if the precise dates and ordering of the losses cannot be determined, it may be necessary to infer from the evidence when they have occurred. Although there is no presumption that losses have occurred in regular and consistent fashion, in practice, an inference to that effect may be drawn. So that if losses have occurred over a period of years, it may be appropriate to allocate them on a time-on-risk basis. Thus, in Municipal Mutual against C Insurance, the decision we just looked at, the assured faced pilferage claims over a 3-year period, and these were allocated by the reinsured on the assumption that losses had occurred equally across the period of coverage, so that they could be allocated on that basis to insurance and reinsurance years of cover. That approach was upheld by the Court of Appeal. Similarly, in IRB against CX3 Insurance, which is also in the bundle, but it's a much more involved exercise to untangle what's going on, the court upheld the view of the arbitrators that losses which arose from product liability claims were to be allocated to insurance and reinsurance policy years on the basis that the losses followed a regular pattern. So the reason I refer to these decisions is it's certainly open to the court to draw an inference to meet the inherent probabilities that in this particular case, the losses of whatever nature which occurred in relation to operating lease policies, containers and finance lease containers were regular and even, but as my lady said earlier, all I need to show is there's no real reason to distinguish finance lease containers and operating lease containers. And that's what I'd ask the Court of Appeal to infer. And when the learned judge below speculated that it might well be, for example, that all the finance lease container losses occurred first, followed by the operating lease containers, that just seems to me inherently improbable. As I say, there's nothing to mark out any distinction between the two types of containers to demonstrate the losses would have occurred at different times.
Just trying to unentangle what is said. There's no presumption that losses have occurred in regular and consistent fashion. In practice, an inference to that effect may be drawn.
I think,
not sure where that leaves one in terms of.
Well, it's not a presumption in terms of a legal presumption. It's not a presumption applies as a matter of law.
It's a pure question of fact based on such evidence as there is at inherent probabilities.
Correct. Bearing in mind, and in this case, the reason this particular inference becomes an attractive one, I would submit, is given the sheer number of containers involved, the sheer number of losses, and the value of those losses when added together. And the question really does become, is it improbable, as I suggest, that all the finance lease losses occurred first, followed by the operating lease losses?
But insofar as it is described as a question of inference, one needs to distinguish between inference properly so-called and speculation.
as always.
The court is permitted to draw inferences. The court is not permitted to speculate.
Correct. And can I make the submission, my lord? I would suggest that when one looks back at what the learned judge was doing in paragraphs 103 to 107 below in his judgment, there were elements of speculation in the sense that the speculation was it may well be, for example, that all the finance lease containers occurred first, followed by all the operating lease containers. That is inherently probable.
What your submission really comes down to is we should find not only that the judge would have been entitled to draw an inference, may draw an inference, which is what this
Yes.
text says, but should have,
Correct.
was required to.
And the reason I say that is because the alternative is that the finance lease container losses occurred in their entirety or in their vast majority before the operating lease containers. That just doesn't make sense. I mean,
Well, it's the unknown unknown, isn't it? And we just don't know what the distinction between these two groups of leases may be.
but there's no evidence before the court to suggest that there is a relevant distinction.
Well, except there is the fact that we've discussed already, namely the trustee in bankruptcy thought that they were materially different because he paid one and not t'other.
But that whatever view the trustee had doesn't translate into when the losses were incurred. So bearing in mind the losses.
But how does one know?
Well,
this is the problem.
Well, if I were a Textainer trying to, for example, I have containers which were lost. I would be incurring costs to recover both types of containers, not just one. And remember, the compensation which was paid in 2019. This is 2 years after the losses which occurred. And also remember that the claim which was presented by Textainer was for both types of container losses. It wasn't just for one type. So if one is going to take into account what the trustee thought, it's also valid to take into account what Textainer thought by presenting both types of loss as a subject of the claim. But I do come back to this issue. There is, other than that consideration, which I don't think translates into any finding or any inference, that it's more likely that finance lease container losses occurred before operating lease container losses. There's just no suggestion of that.
I feel slightly cut adrift on this thing. I'm not sure I really understand what process we're talking about. That the containers were leased on one or other form of lease and were delivered to Hanjin at some point. And at that point, the deployment of those containers was entirely a matter for Hanjin.
Yes.
So to what extent does Textainer have any information about the current location of those containers?
Well, it will know where it delivered it. I don't know what container tracking devices they've got. I don't know what reports were being received by Hanjin.
And is there any difference in the tracking of operating lease containers and finance lease containers?
There's no evidence before the court. I can't say.
So it may be that they are tracked differently.
But that's speculation, my lord, if I say that.
Well, it's speculation to say that there isn't a difference, isn't it?
Well, no, all I'm saying is there's no evidence. I'm saying there's no evidence before the court which would justify a distinction being drawn between the two
But
types.
that's where you're really asking for there to be a presumption in favour of equality, aren't you?
No, I don't think I am. All I'm asking, in the same way, is Lord Justice Hobhouse was considering a scenario where regular pilferage took place over a period of time. And the question is, should it be assumed, in his case, that it was sustained on a straight line basis over an 18-month period? And he said yes. There was no reason to confine it to, for example, the second contract period.
Right. So this then takes us on to the question of the burden of proof, because one way of looking at this is to say, on whom does the burden lie? And since you're claiming, it lies on you. And if there's insufficient evidence, then you've failed to discharge your burden.
Unless the inference can be proper. Well, I say there is evidence of some sort, which is the schedule supporting the claim. There is evidence of some sort. There's also no evidence of a distinction to be drawn between the two types of containers. And the inferences applies in these sorts of circumstances. It's exactly the same sort of circumstances I would submit as arose in the municipal mutual. One has to be very careful about and when I ask oneself this is very easy to test, and I've said it before, I'm sorry if I'm repeating myself, but it's inherently unlikely that losses of the one type preceded in the whole or the majority losses of the other type. It's inherently unlikely that the finance lease loss container losses preceded the operating lease container losses. That is inherently unlikely. Now, one has to be careful of the burden of proof. Just imagine the scenario where, which I raised earlier, just imagine the insurers, for some reason, were undertaking the subrogated proceedings against Hanjin and recovered the compensation directly to themselves. And at that point, it was Textainer who was deciding that it should sue the insurers for the recovery. Then the burden of proof would be on Textainer. And all the arguments which, for example, the learned judge relied on below, or in order to decide that my clients hadn't discharged the burden of proof, would apply equally to that. But that seems an incredibly whimsical approach in circumstances where you're dealing with the same principles, dealing with the treatment of the same recoveries. All it really depends on is who's received them in the first instance. Whereas the inference cures all the ills associated with what I would describe as the inherent probabilities. And it's perfectly legitimate to draw in these circumstances. So unless there's anything further on the second issue, I propose to deal with the third issue, which I can deal with quite briefly.
Yeah.
So this is assuming that the top-down principle would be applied to the circumstance of loss in this case by virtue, if it was a non-marine policy. But so if it was a non-marine policy and everything I've argued about the top-down principle not being applied is wrong, which I obviously submit is not the case, but just so it's understood, I'm arguing against myself. Then the question arises, is there a different approach to be adopted in the case of marine insurance policies? And the principle is set out in an interesting way in Section 81 of the Marine Insurance Act, which is at page 247 of the authorities bundle, tab 16. So Section 81 provides where the assured is insured for an amount less than the insurable value, or in the case of a valued policy, for an amount less than the policy valuation, he, the insured, is deemed to be his own insurer in respect of the uninsured balance. So if we take a very simple example, if one has a ship which is worth $10 million, but the ship is actually only insured for $5 million. Now, if it's a non-marine insurance, because what the principle referred to in Section 81 is the principle of averaging, essentially, and I can make that good. But if it was non-marine insurance, then any losses up to $5 million would be recoverable, and losses in excess of $5 million would be uninsured. So averaging doesn't apply. So it operates essentially as an excess of loss policy, because you're only insuring the first 5 million, not the second 5 million. But if it's a marine policy, by virtue of Section 81, the insured is treated as its own insurer for that 5 million, which is uninsured. So in other words, if you might well have two insurers, one insuring half and the other insuring the other half. And in those circumstances, what happens if there is a claim, even for an amount less than 5 million, the insured can only recover from the insurer the proportion which is insured. So just going back to my example, it's a $10 million ship, $5 million insurance, but there's a $1 million partial loss, a cost of repair for minor damage. So that if it was a non-marine insurance, that $1 million would be recovered because the principle of averaging doesn't apply, and it comes within the limit of the policy. But if it's marine insurance, the insured only recovers half because it's treated as its own insurer for the half which is uninsured. And this is a point which is made good in a case called Commonwealth, which is referred to in tab 3 at the bottom. So in this case, the owners of look at the head note, the owners of the steamship, which had run down a schooner, paid into court £1,000. The value of the schooner, as assessed in the registry, underwriters who had paid the owners of the schooner £1,000 as being the amount for which she was insured, under a policy stating that the value to be £1,350, claimed the £1,000, and held by the Court of Appeal that the owners of the schooner were entitled to be treated as their own insurers for £350, and therefore the £1,000 must be divided between them and the underwriters in the proportion of their respective interests. So here, even though there was a policy valuation of £1,350, the actual insurance was only for £1,000. And so only 10 over 13.5 was insured. The remaining 3.5 over 13.5 was not. And the court dealt with the issue at page 49. And I'm not going to read it out, but you can see in the page 49 or 223 of the report the way in which the court has approached it. Now, the reason this is important in this context is that even though there is underinsurance, just imagine this, we're talking about one layer of policy. There's underinsurance in a marine context. Therefore, if there were an indemnity paid, it would be paid according to that proportion. So, for example, on the Commonwealth example, 10 over 13.5 were recovered by the insured, but the other 3.5 over 13.5 would not be. So that would be the way that the relevant recovery would be treated. Now, the mere fact you have another policy on top of that to deal with losses, total losses which are underinsured, because we have a program here which is 85 million, and the losses exceed 100 million. So even though you've got 5 or 6 layered policies with a retention at the bottom, there's insufficient insurance, so it's underinsurance in this context. And this is where the principle of averaging applies. This supports a proportionate approach rather than the top-down or excess of loss approach. Now,
isn't it conceptually quite different though? Because if you insure a vessel that's worth 1,350, you're liable for, as it were, any damage to that 1,350, even though you've only insured and received a premium for 1,000. But that's different with excess layers. You are only insuring and are liable for the layer. You're not liable for the other layers. And indeed, in this type of insurance, it would be impossible to determine what was. You could never be sure you got full insurance because you just don't know what the total liability could be. And it's like with liability insurance, you never know just how many millions the professional might ultimately be sued for. And you can never be sure that you were not.
There's a difference between liability. Liability insurance, there's no real concept of underinsurance in that concept because you're liable and you can recover up to the limited liability. When you're talking about property though, which has a value, remember the value, the value referred to in these relation to these containers is the book value. Yeah. Then the question is there enough insurance to cover the entirety of the value or not? So liability insurance, I would submit, and even financial loss insurance in a sense, must be treated separately from property insurance. Property insurance is where you have real issues of underinsurance. And my point is this, that the mere fact that the underinsurance happens to be structured by 6 policies rather than 1 makes no difference. You still have underinsurance.
So by having aggregate containers out on lease to Hanjin in excess of the single limit per,
There's a
Lessee,
commercial risk being taken by Textainer.
you say that's underinsured.
Yes. Now, I think there are 2 points I need to make. One is this, that this issue was considered briefly by Lord Justice Staunton in the Court of Appeal in Napier and Hunter. Well, of course, Napier and Hunter is not a marine case, and it's probably worth my just taking you to it. Just a little bit of a spoiler alert. He expresses a view which is contrary to the position I'm putting forward, as is the editor of Arnold. So they're two. So I recognise the challenges which face me on this particular issue, but I'll bring them to your attention because I need to refer to them. So the first one's at tab 5. And it's Lord Justice Staunton's judgment begins at page 72 of the bundle or 21 of the report. But if you go to page 23 of the report or page 74 of the bundle. In the right-hand column, page 23. Lord Justice Staunton, in the second paragraph, having referred to the figures which were used essentially in Napier and Hunter as the illustration, about halfway through the second column, he says, "I accept the top-down method of the insurers." Do you see that? For my part, I consider that the solution is clear and free from doubt. The same answer would apply if the recovery had been effected before the insurers paid. The parties to the insurance contract provided that the name must bear the loss to the extent of £25,000 before any liability fell on the insurers. That the name must do. We referred to Goff and Jones. The problem there considered is that of underinsurance, where property is insured for less than its value. The authors do not appear to touch upon liability insurance, where the insurer takes upon himself a sliced layer or stratum, nor, as we were told, do any of the cases deal with that topic. The doctrine that emerges in the case of underinsurance on property can be summarised as follows. In a non-marine policy, the insured is entitled to recoveries until his loss over the policy limit is reimbursed. But if there is an average clause, a different rule applies, which is the same as that prevailing in marine insurance. By Section 81 of the Marine Insurance Act, where the insurance is for less than the insurable value, the assured is deemed to be his own insurer for the balance. Recoveries are then divided pro rata, the Commonwealth. But where there is an agreed value and one or more insurers underwrite the whole of it, they're entitled to all recoveries until they've been fully reimbursed. Gould and Hull and Ocean Marine. None of these points seems to me to touch on an insurance effected on a layer, slice, or stratum. I would allow this appeal on the second issue, Mr. Donaldson, for the insurers, when reminded of the mortgage rule that you redeem up and foreclose down, said in this class of insurance you pay up and recover down. That seems to me to put it neatly and accurately. Lord Justice Staunton dealt with this point after referring to the authorities in a sentence on the top of page 24. So it's unclear whether he was actually applying his mind to marine insurance as such or just to the facts at hand. But it seems, insofar as he was applying his mind to marine insurance, I'm afraid it doesn't involve an enormous amount of analysis. It's a single sentence. And in this particular occasion, with all the respect I can muster to Lord Justice Staunton, I'm afraid he's just got it wrong. But his explanation of the law approach dealing with averaging is correct. So all the premises he refers to earlier on are correct. The only other point I make, and I'm not going to read it out, my learned friend I'm sure will, is the comments of the editors of Arnold, which is at paragraph 3146, it's tab 15, page 238. and and there's a long discussion. It goes on to page 240. And I think it's fair to say that the editors, having discussed the matter in the round, come to the view that the top-down principle apply even in a marine policy case. But I'll let my learned friend develop that point. So, there was also a respondent's notice by Textainer on the assumption that this particular issue is found in my favour, that the averaging principle does apply. I think even then my learned friend says, well, that this should still be top-down within the insured elements to both the fourth and fifth excess layers. And I think I'd prefer to hear my learned friend on that before I respond to it. So if I could just conclude with the following. As I say, I need to succeed on issues 1 or 3 and 2 to succeed. My primary case is issue 1, which is that the top-down principle is inapplicable for the reasons which I will not repeat, but which I have submitted, and that in order to get around the factual finding made by the judge, I will need to rely upon the inference which I say can and should be adopted by this court as to the circumstances in which finance lease and operating lease losses and their respective timing. So with those submissions, I would invite the Court of Appeal to allow my client's appeal, unless I can help you further.
Can I just ask you? Sorry, can I just ask in relation to issue 3? Are you saying that you also have to succeed on issue 2 to succeed?
Yes, I think that's.
It's not what you say in your skeleton.
Didn't I?
No, the
Maybe I
skeleton indicates that issue 3 is separate from issue.
It may well. I think it is actually on reflection. I think it may be. Can I reflect on that? Unless my learned friend wants me to commit myself at this particular point.
I'm quite happy to accept that if my learned friend succeeds on issue 3, then subject to the respondent's notice, the appeal succeeds.
Then I think that's entirely right. I don't know why I got confused, but I'm very sorry for that.
Very good.
Very good. Unless there's anything further.
Thank you. Mr. Smith.
My lords, my lady, as my learned friend has said, the grounds of appeal and the respondent's notice taken together reveal 4 main issues, and if I can just recap those, because I'll no doubt put them slightly differently to my learned friend. But the first is whether the learned deputy judge was wrong to conclude that the top-down approach applied. The second is whether the learned deputy judge was wrong to decline to draw inferences, or that's how it's put in the appellant's notice, but I think the judge put it, make assumptions in the claimant's favour. The third is, does the principle of averaging apply? And the fourth is the point that we deal with in our respondent's notice, which is that if the principle of averaging applies as between the insurers on the one part and the insured on the other, how are the recoveries then distributed between the insurers themselves? So if X% goes to the insurers and Y% goes to the insured, how is the X% distributed between the insurers? And we submit that that is still on the top-down basis within the programme. And the net effect, if we're right on the respondent's notice, is still that the appeal falls to be dismissed, because as the court is aware, my clients stand as the assignees of the insurers of the fourth and fifth policy. So we would still mathematically have enough to keep the whole of the recovery. And so unless my learned friend succeeds either on issues 1 and 2, and he needs to be 1 and 2 to start with, or on issues 3 and 4, the appeal should be dismissed. And to outline the submissions I'm going to make to the court, I'm going to start, if I may, with some general introductory comments about the nature of the insurance programme that are relevant in our submission to all of the issues that the court has to consider. And that's because, in essence, we say that Textainer is entitled to recover the whole of the sums recovered and any further sums to be recovered, because they represent, on a proper analysis of the policies, and whether one's looking at averaging or at the top-down approach, either Textainer's own uninsured losses, so above the level at the top of the programme, they represent recoveries due to the insurers of the fourth and fifth excess layer. And we suggest to my lords and my lady that in answering the four questions I've posed, there are two overarching points that need to be borne in mind. And the first is that the court is concerned with 6 separate and distinct policies of insurance, each written by a different group of insurers, albeit on identical terms. I say identical terms, that's save in respect of the fifth excess layer that didn't cover loss of earnings, but otherwise identical save as to the amounts. And secondly, the cover provided by that programme does not relate to a single asset with a known value, or even perhaps a group or fleet of assets, as one sometimes sees with hull and machinery insurance, with a known value. It relates to losses that are aggregated together for the purposes of the programme. And those fundamental points underlie the submissions I'm going to make. And as I've said, the court is not therefore concerned with a single policy of insurance covering a single asset with a known value, as it would be in a paradigm marine insurance context, for example, a ship, to mean that if that cover was not sufficient to cover the insurable value of the asset, the principle of averaging would apply. And we'll need to come on to look at that in the question when we come to issue 3 on averaging, because I think, as my Lord Justice Phillips put to my learned friend, one has to look at the fact that this is an excess of loss programme, not property insurance. When we come to look at Napier in the Court of Appeal and what Lord Justice Staunton said, there were some words in parenthesis that when my learned friend read out the passage from his judgment, he skipped lightly over, which I will be drawing the court's attention to. But when one has an excess of loss programme, like a liability insurance, the potential losses are infinite. And therefore fixing an insurable value is not possible. And that is why, in essence, one can't take the paradigm marine insurance approach and an averaging approach, and one has to instead focus on the reality of a programme of insurance in layers and strata. And so, just to look into that in a little more detail by looking at the programme, it's common ground that the programme does consist of 6 separate policies. They're referred to as various policies in the claim form, and a number of different insurance contracts in the re-amended particulars of the claim. And each policy covers losses which Textainer might suffer at some stage in the future. So this again goes to the question of whether one can say, here is an asset, some property that is insured with a known value. I hope we don't need to pick them up. We can, if necessary. The re-amended particulars of claim correctly describe the programme as an excess of loss programme by which the underwriters agree to, quote, indemnify Textainer against specified types of loss. And they go on to refer to Textainer suffering, quotes, more than 95 million of losses and claiming indemnity in respect of such losses. Again, correctly reflecting the fact that the proper construction of the policies is they insure against losses. And if I can make that good then, by asking my lords and my ladies to have the insuring clauses and the policy, which we've looked at before, at divider 13 of the core bundle. Picking up, first of all, at page 164, the total sum insured is 5 million in excess of the assured's retention. The annual aggregate limit, single lessees, is 5 million, and the annual aggregate limit is 10 million. And we'll come on to look at the clauses dealing with that and the point my Lord Justice Arnold raised this morning. The assured's retention is defined as all, for all other claims, which is the claims we're concerned with, it is the amount of 5 million. And we then see the insuring clauses, first of all at 165, providing for the insurers to indemnify the assured to the extent provided by this policy is lost, destroyed or damaged whilst being moved, delivered or repositioned. Now, our understanding of how this this particular insuring provision is intended to work is that it is dealing with containers that Textainer is moving around on its own account rather than on hire containers, and that is appears from the words moved, delivered or repositioned. So this is containers being moved around to be delivered to another lessee or repositioned. And one can see consistently with that the first extension at page 166 is in respect of new equipment. So if one has new equipment that's being delivered to Textainer to form part of its fleet, the relevant insuring clause is section 1 there.
No, it's prior to delivery.
Prior to delivery, indeed. So new equipment prior to delivery. And then on hire equipment, which is what we're concerned with, is page 167. Now, I have to accept that, somewhat curiously, the insuring clauses on page 167 don't appear to provide for an indemnity in respect of actually losing a container. Which is no doubt why my learned friend says that the insuring clauses with which the court is concerned are those at 165. But the clauses at page 165 don't seem to us, with respect the apposite, to describe the loss of a container that is on hire to a lessee. And so it seems to be some unhappy wording between the two pages. But when one then goes on to look at the definitions clause and the claims conditions, it will be our submission that it is clear that the intention of the policy is that a claim in respect of on-hire equipment is covered by the extension at page 167, and that appears to be how the parties treated it.
And it's just slightly off. The first heading in that extension is lost equipment.
Indeed, my lady, and it does appear to be the intention that that paragraph should cover lost equipment, but I have to accept that actually on the wording of it, it doesn't. But equally, the insuring clauses at page 165 don't appear to us to be apposite to cover containers that are on hire to a lessee that becomes insolvent, which is the situation the court is concerned with. Happily, certainly from my point of view, the claim has been paid, so I don't have to persuade the court which insuring clause is engaged. This debate is only relevant when we come on to look at how the policy pays and therefore how the recoveries are recovered. And in that respect, can I ask the court to go on, please, to page 176, which is the claims conditions. I'm going to start here rather than with the definitions, because the notification provision is in our submission important to understanding how the policies work. On the discovery of any circumstances which may give rise to a claim under the policy, and we'll go back to the definition of claim, this is the top of page 176, the assured shall immediately notify Arthur J. Gallagher UK Limited in writing thereof, who shall in turn immediately notify the insurer. And then next, equipment retrieval and receivables recovery. So again, we're positing this on the basis that the containers are on hire to a shipping company, Hanjin in this case. So on the discovery, again, of any circumstances which may give rise to a claim under the policy, the assured must, as a condition of the policy, demand return of all equipment and payment of any outstanding receivables. Such demand must not be rescinded within 1 year of the date it is issued unless, and then there's provision for the demand to be rescinded basically if the solvency of the lessor, the lessee, is made good. So the assured is fully satisfied as to the financial standing of the lessee or the depot. I should say there are various references to depot because this insuring clause covers containers that are at the depot as well as in the possession of the lessee. So we see there the provision for a notice to be given to the lessee, and that is reflected at page 174. If we go back to the definitions notice of default. The assured's notice to a defaulting lessee or depot for the return of its equipment and payment of any outstanding receivables. So what appears to be envisaged,
Sorry, which page is that?
174, the definition of notice of default, my lady, I apologise. The assured's notice to a defaulting lessee or depot for the return of its equipment, and that is in our submission clearly the notice envisaged by the paragraph I just took the court to, the equipment receivable and receivables recovery. So the assured Textainer gives a notice to Hanjin, please can we have our containers back and please will you pay the recoveries. That's a condition of any recovery being made, sorry I should have said may we have our receivables, and that is a condition of any recovery being made under the policy. And there is then the definition of date of occurrence and occurrence, which we saw at page 173. So the date of occurrence is the date of an event which may give rise to a claim recoverable hereunder. So that's the same wording as triggers the obligation to make a claim through Arthur J. Gallagher and to serve a notice on the lessee. And the date of occurrence is the first of the following to occur, and then we see various events of insolvency and analogous events. And in this case, it is common ground that when Hanjin petitioned the Seoul court in August, 31st of August 2016, applied for bankruptcy, that was the triggering event. And Hanjin then entered into what some of the documents refer to, I think picking up a Korean phrase, is rehabilitation. So a period before the bankruptcy is actually ruled on by the court. And it's important to note, and we can see this from how the settlements were made, that during that period, Hanjin continues to use some of the containers and continues to pay higher in relation to some of the containers. And this was an issue that was before the judge, but needn't trouble the court. But as well as the recoveries the court is concerned with, there had been recoveries made earlier by my client that reflected the ongoing rental for the containers that Hanjin continued to use during the period of rehabilitation. So
How does date of occurrence and notice of default fit in with claims under the sections of the policy on 165 and 166?
On 165, my lord, with some difficulty, which is one of the reasons I was saying to my lord that that provision does not seem to us to be apposite to be covering the situation we're concerned with. It fits with 167, which is why I say these are the insuring provisions we're really concerned with. Because what you have is an insolvency followed by the notices I suggested to the court, and then the various insuring clauses, which, amongst other things, as my lady pointed out, cover or appear to cover from the titles, lost equipment. So one serves one's notice on Hanjin, and then one sees, in respect of on-hire equipment, I'm now at page 167, the insurers will indemnify the assured to the extent provided by this policy for, and then the 5 heads of losses, and then at the end of the page, caused by or arising from the failure of any lessee to fulfil their obligations to the assured with respect to such equipment. So essentially, if the lessee defaults on the leasing agreements and either fails to pay the rental or fails to pay costs to repair damaged containers or fails to redeliver the containers to Textainer, then those give rise to claims if, certainly in relation to recovery, the container has not been recovered within 183 days of the date of occurrence. And the 183 days we see referred to there is also the limit for the loss of earnings claim on page 168. So again, I have to accept the wording in this clause is not clear, but it does seem to us that looking at all the provisions together, it is clear how the policy was intended to operate. And to make that good even further, at page 169, if I can then just pick up on the general conditions and definition. The policy limit is defined as follows on page 169. irrespective of the number of parties claiming under this policy, the total amount payable by the insurers in respect of all claims arising out of any one occurrence shall not exceed the limit of liability or maximum amount payable specified, or in the whole the total sum insured. So reading that then together with provisions that we looked at earlier, what one sees is that under each policy, for any single lessee, there's an aggregate limit of 5 million. But for any claims during the policy year, there's an aggregate limit of 10 million, which means, for example, that if my client suffered 15 million from 3 different claims, they would only recover the 10 because that's the aggregate limit for all claims in the policy year. And that's going to be relevant when we come to look at the no drop-down provision in a moment. So picking up on that then at 173, the annual aggregate limit, consistently with what I've just suggested, is the maximum amount the insurers will pay for any claim or series of claims occurring or with dates of occurrence during any one annual period of insurance. So for one occurrence, the aggregate limit is 5 million. The annual aggregate limit single lessees, again, the maximum amount the insurers will pay for all claims attributable to any individual lessee or group of lessees during the period of insurance. So if there are 2 occurrences in a period of insurance for one lessee, the aggregate limit is still 5 million. And then the assured's retention we've seen, and claim is defined as the aggregate of all losses and damages, including all costs and expenses suffered by the assured resulting from each occurrence insured hereunder. If one reads that together with the limits of liability, we submit that it's clear that what that means is that a claim exists where the aggregate of loss and damages exceeds the layer below, but does not exceed the limit in the policy. And the last 2 provisions I wanted to take my lords and my lady to in the definitions, which we have already looked at, is the date of preliminary claim, a date not later than 6 calendar months after the date of occurrence, when the assured, having submitted written claims to the lessee, so that's again the notice that we've submitted to the lessee or their legal representatives, remains unable to recover equipment and or amounts due from the lessee in respect of the period after the date of occurrence. So again, I have to accept, as the learned judge found and my learned friend has pointed out, this definition is not then referred to anywhere else in the policy. But what seems to be envisaged is a preliminary claim where the assured says, well, 6 months have gone past, I served my notice on the lessee and they still haven't returned this number of containers and they haven't paid this much rent and I have incurred expenses of this much. And then the date of final claim, further up the page, is the date exactly 12 calendar months after the date of occurrence or otherwise as may be agreed. And just picking up on that, if I could show my lords and my lady the claim document submitted to the insurers. So not the document we've been looking at in the Hanjin, but supplemental bundle tab 5, page 23. This is the document that sets out the claim made against the programme, and it is headed top left-hand corner, Hanjin final claim amount, September 2017. So it appears to have been drafted with the definition of final claim in mind. And this sets out the various losses that were claimed against the programme and indemnified, firstly as at the 21st of September 2017 and then updated in March. And what this shows, firstly, as I mentioned when I intervened earlier, that the losses of revenue have been apportioned out so as to take out of account that amount of lost revenue that would otherwise have been insured by the 5th excess layer. And my lords, my lady will see that there is no change between the figure for the 21st of September and the 9th of March. That is because by the 21st of September, the 183 days has already elapsed, so no more income is
Sorry,
covered.
you said 9th of March. Did you mean 3rd of March?
I meant 9th of March because I was reading in the box at the top right-hand column.
Oh, sorry. Yes, sorry. I see. Thank you.
Yes.
Sorry, no change in the.
So there's no change between September 2017
Yes.
and 9th of March 2018
Yes.
because, and I think this is where my Lord Justice Arnold got the other March date, unrecovered equipment at 3rd of March was the maximum, that's when the 183 days expired.
Yeah.
So the 183 days had expired and therefore the loss of revenue is crystallised. But again, to touch on one of the points raised with my learned friend this morning, what one can see is that that loss of revenue is divided up into 5 different categories, which is leases that expired on or before the 1st of September 2016. And there's no loss of revenue then, because even though there may be outstanding revenue, that's not indemnified because it doesn't fall after the date of the occurrence. Leases expired on 31st of December 2016, so there seem to have been 38 containers subject to that. Equipment returned on or before the 2nd of March, so that's within the 183-day period. Direct interchanged units and unrecovered equipment as at the 3rd of March. So for the equipment you never recover within the 183 days, you only get the 183 days rental. So one can see some of the leases coming to an end during the period when cover was provided. But what one then sees under unrecovered units, and sorry, can I just ask, save going backwards and forwards to these documents later, if I could ask my lords, my lady to perhaps put a finger in tab 5 and look back to tab 2, which is the claim we submitted to Han Jin. A note at this stage, the total rental figures claimed against Han Jin for the period up to February 2017 were 19 odd million, which actually exceeds the total rental figures claimed against the insurance programme, which provided cover through till the 3rd of March 2017. And the reason for that, as I understand it, is the cover provided by the programme is not coextensive with the actual outstanding rentals which we claimed from Han Jin. So that's the first reason for treating this schedule with some caution when we come to the 3rd point of the appeal, insofar as it's said that it provides any evidence about what was indemnified by the insurers. The second point, if we could then go back to page 23 in this bundle, I think it was my Lord Justice Arnold asked whether there had been some recoveries of containers during the relevant period. What one can see is that the total number of containers involved to start with was 113,676. One sees that from the total number of units. We can look either in the September 2017 or the March 2018 column. The total number of units is 113,676. By the time one comes to consider the claim for unrecovered units, as at 21st of September, there are only some 9,420 that are unrecovered. One sees that from the first line in Part B, 9,420 under number of units. And by the time it's March 2018, that's gone down yet further to 8,820. So those are recoveries that are being made in the period during which the claim has been advanced against the insurers. So between the final claim and the updated claim. So recoveries are being made, but what we then see, therefore, is that the value of the claim for unrecovered containers going down from 21 odd million, 21,945 to 21,199. And again, if we can compare that total figure of 21 odd million to the figure claimed against Han Jin going back to tab 6, the total of unrecovered book values is 80,366,487. And again, that makes it very difficult in our submission to look at the claim as presented to Han Jin and attach to it any weight when considering the claim and how it was apportioned between the insurers. I'll use that word neutrally for the moment, and therefore how any recovery should be apportioned. We're looking at completely different figures, comparing apples with pears. And then the total recovery costs in item C, as we would expect, because the number of containers has gone down, the recovery costs go up from 35,847 to 36,093. And again, this is all within the period after the final claim. And one then sees the final claim figures. You've got repair costs going down. The reason repair costs go down is because you've got projected repair costs. And in fact, once more recoveries are made, you don't spend quite as much as one thought one might. And therefore, the projected repair cost, not yet repaired nor estimated, goes down. And the total claim, as at March 2018, 95,649,804. And then mathematically, if we add back in, while we're on that page, if we add back in the lost revenue not recoverable against the fifth excess layer, mathematically we get a figure as at September 2017 of 103,158,114, and as at March 2018, 101,856,624. And that's why when the judge reached his figure for the percentage, which applies if my learned friend is right, he took those higher figures. That was the total claim against the programme. And what we submit, looking at the insuring clauses we've looked at, and the claim made against the insurance, is that it's clear from the way the claim is structured that the submissions I made to my lords and my lady as how the claim handling operates, that what we have been indemnified against is the losses sustained, including, I accept, some lost containers, as a result of the insolvency of Hanjin. And in fact, the original application for bankruptcy, its common ground between the parties is the date of occurrence for the purposes of the policy. And the significance of that in our submission is this. Although the programme provides, in a very general sense, insurance relating to containers, it is not property insurance in the paradigm sense, as one might have a hull and machinery insurance on a ship. It is insurance that indemnifies against losses, certainly as far as we're concerned, caused by the insolvency of a lessee or possibly a depot, and by the failure, in this case, of the lessee, Hanjin, to return containers in accordance with the demand that we made pursuant to the policy and pay rentals accruing during a 183-day period. And there are a number of respects in my learned friend's skeleton that, notwithstanding the references in his pleading that I referred to earlier, that he subtly changes the way he describes the policy. He refers to it in his skeleton variously at paragraphs 1, 3 and 6 as specified, a policy in respect of specified marine container losses, or a programme covering container losses. And I think on one or two occasions during the course of his submissions today, he suggested that certainly as regards the container, it might be viewed as property insurance as such. But in our respectful submission, the programme is and remains an excess of loss programme, and that is important. I can illustrate that in this way. As I've said, there's no tangible object or property that is insured. And indeed, if the insolvent lessee had returned all the containers within the 183-day period, or perhaps within the 6-month period prior to the preliminary claim, or perhaps within the 1-year period prior to the final claim, but in any event, returned the containers, there would be no claim for loss of the containers. There would only be claims for lost earnings and possibly damage to the containers if they were returned in a damaged condition, and possibly if the lessor incurred the costs of recovery for the costs of recovery. So this is a programme that, at least in that circumstance, would be no more, no less than a policy of indemnity in respect to the losses that are suffered. And the fact that in some cases there are unreturned containers doesn't change that fact. And that is why it is important, as I've said to the court already, that each policy covers an identified slice or strata or layer, the cases use various phrases, of the potential losses. And again, I stress the word potential because at inception, nobody knows what the potential losses are. And to make that good and put the figures on it, firstly, as the court is aware, Textainer is required to bear the first 5 million of any claim. We've seen that from the definition of the assured's retention. And as regards a single lessee, and for the purposes of the next few submissions, I'm going to deal simply with a single lessee rather than the aggregate annual limit. As regards a single lessee, the primary policy then provides cover in respect of 5 million worth of losses in excess of retention, subject to the aggregate limit of, as I've said, 5 million per single lessee. The first excess policy then includes a no drop-down clause. Now, we don't actually have that because we don't have the first excess policy, but it's quoted, if I can ask the court to look at it, in paragraph 5 of our defence, which is core bundle tab 12, page 155. And pausing before I go to the actual terms of the no drop-down policy, but to remind my lords and my ladies that the case my learned friend took the court to, the Supreme Court case, Lord Mance's judgment, it involved a policy that specifically had a drop-down provision, so that it did allow one layer to drop down to the next. But in our case, each of the excess policies has this wording, but with a different figure. Notwithstanding anything to the contrary in the terms and conditions of the primary insurance, or this insurance, it is understood and agreed that this insurance shall always apply in excess of 10 million for any loss or series of losses arising out of one occurrence. In the event that the underlying insurance aggregate limit is exhausted, this insurance shall not drop down or in any way apply as primary insurance. The insurance shall then apply in excess of 10 million for any loss or series of losses arising out of one occurrence, which shall be account for the account of the assured. So, as I said, if the primary layer has paid out on perhaps 3 claims and exceeded the annual aggregate, so there's no more cover in the primary layer, the first excess still only kicks in when we get to 10 million. It is strictly limited to the slice beginning at 10 million and ending at 15 million. And that's important because it means that the first excess can't be asked to pay anything below the amount they've agreed, the layer they've agreed to insure. And there's a similar no drop-down policy in each of the other excesses with the appropriate amounts in. So if there are multiple claims in 1 year that erode the primary, the first excess still only pays in excess of 10 million. And that confirms the important fact, as I've already submitted to my lords and my lady, that the structure of this programme is that the underwriters of each layer agree to provide for cover for losses within their layer or stratum, but not for anything below that and not for anything above it. And that is why, in our submission, it is appropriate, and my learned friend took the court to Lord Justice Staunton in paragraph 24 of Napier, that this programme pays up. And by that I don't mean that they pay when they're asked to. What I mean is they pay from the ground upwards. And of that in our submission, there can be no doubt. It's the way the entire programme is structured. And at first instance, certainly in the evidence, and I think in some of the cross-examination, the phrase that was used by both parties and I think by my learned friend's witness was that one had to look at whether the losses had burned through the policy. So you burn through each layer in turn, and on the facts of this case, the overall losses burned through the entire amount of the excess. And it is that fact, the fact that the policy pays up, that underlies the reality check, which we invited the learned deputy judge to undertake, and he refers to it paragraph 70 of his judgment, and which I refer to in paragraph 42 of my skeleton for this appeal. And I won't go through the details, but if I can just outline how that works, because in fact it's remarkably similar to some of the points my lords and my lady have been making to my learned friend during the course of his submission. Clearly, we would suggest the net position of the parties, and by that I mean the various insurers separately considered and Textainer, should be the same, irrespective of whether the recoveries are made before or after the insurers have paid the claim. If there is any doubt about that being correct, that is what Lord Justice Dillon said in Napier, page 21, the right-hand column of the report, which is page 72 of the authorities bundle, in turn referring to Gould and Ocean Marine, which is also in the authorities bundle. But I don't think there is any dispute about the fact that as a matter of principle, the position should be the same. If, applying that, Textainer had recovered, for example, the whole amount, and I'll assume for these purposes the whole 25 million, even though so far we've only recovered 14 million. If we had recovered the whole 25,886,000 before the insurers had paid the claims, all that would have done would be to reduce the total amount of the loss from the figure of 101,856,000 that I gave to the court earlier when we were looking at the schedule, to 75,969,000. That, of course, would still exceed the programme, or certainly the fourth layer. Even if one allows for the fact the fifth excess layer didn't provide an indemnity in respect of lost earnings, so one takes out the lost earnings by the formula I showed the court when I looked at the claim schedule. Again, just for the note, page 23 of the supplemental bundle, one gets to a figure of 95,649,804. And if one deducts a recovery of that, for a recovery of 25,886 from that, one still has a loss of 69,763,000. What that means is that if the recoveries, so the total recovery that we agreed with Hanjin, had all been received before any of the insurers paid out, the total loss would still have been substantially in excess of the limit of the fourth excess policy, which is the 5 million retention, 5 million primary, 5 million first excess, 5 million second excess, and 25 million third excess, and 10 million, so 55 million. So what that means mathematically is that if we had made the recovery that the court is now concerned with before the insurers paid out, the first, second, and third excess layers and the primary layer would all still have paid out the full amount of their indemnity. And that reflects the fact, which is why I showed the court the recoveries of containers that were made during the period of the claim. That reflects the fact that the containers we did recover didn't reduce the liability of the primary layer, the first, second, or third excess to pay. Because even crediting the value of the containers that we recovered during the period covered by the claim still exceeded their liability. And we submit that there's no reason of law, equity, or principle why the claimants should be better off by the happenstance of the fact that they paid the claims before the recovery was made than the other way round. And so, and I'll come on to look at Napier in due course, that is why we submit that as well as paying up, the correct approach is recover down, to use the second phrase Lord Justice Staunton used. And there is another reality check that the court could carry out which is that the judge undertook at paragraph 96 of his judgment. If I could ask the court to look at that. Court, tab 8, page 109. And essentially, I'll paraphrase, but I hope accurately, what the learned deputy judge posited was that if certain recoveries could, on the learned friends approach, be specifically identified in respect of certain identified losses, so that removes the need for the assumption that he contends for on his second ground of appeal. And if those recoveries apply to a loss indemnified by the primary layer, or even actually by the insured as part of its retention, then on the learned friends approach, the benefit of the recovery goes entirely to the primary layer. And that's a little bit like his $5 million container. What that means is that the bottom of the programme, so either the primary layer or indeed possibly the insured, if it's all within the retention, is made whole, and the entire loss falls on the top layer of the programme. And that cannot, in our respectful submission, be the correct approach to a programme of insurance, excessive loss insurance and strata. And so those are the submissions I wanted to make by way of opening, looking at the policy and the overall approach, because they colour to an extent submissions I'm going to make and hopefully lead into and shorten some of the submissions I want to make on the specific points. Can I ask my lords, my lady, what time we're sitting to? Are we at...
Well, normally we sit till 4:15, but one can stop earlier or later, depending on what's convenient.
Well, my lords, my lady, I was about to start on the top-down approach. I think it would be helpful if I outlined our submissions on that. That will take me to about 4:15. Then I may well be able to trim some of what I was going to say on the top-down approach in the light of this morning's exchange.
All right, very good.
In relation to the top-down approach, these submissions build on the overall outline submissions I've made. We agree with my learned friend when he says that the starting point is to consider the wording of the recoveries, where he said a number of times, he stressed as or towards the payment of the amount indemnified. And that is the provision of the recoveries provision that he mentioned. So we don't need to turn it up again. Core tab 13, page 177, the recoveries condition. What has to be brought into account is any recovery as or towards payment of the amount indemnified. And that reflects the law in relation to subrogation generally. And again, we probably don't need to turn it up. The two provisions of McGillivray that my learned friend took you to both stress that the right for the insurer to benefit from the recoveries is engaged when the recovery is, quotes, for the loss for which the insurer has indemnified the insured, or the loss in respect of which the insurer has indemnified him. Those are the phrases used in the two paragraphs. And it is for that reason in our submission that the underwriters, and the burden of proof must be on them, it is their claim to be entitled to these recoveries, need to establish that part or all of the monies that we have recovered was or were recovered as or towards the amount indemnified by that policy. So that's again why it's important that this is a policy in slices or strata. And that's again why it's important that we have 6 different insurance policies. My learned friend groups his clients together and invites the court to hold that they're entitled to the 39.3 or 33.9, I'm afraid I forget which.
I think it was 39.3.
I think it was 39.3. I was right the first time. I shouldn't have doubted myself. That percentage of the recoveries, but in reality, his claim on behalf of each group of insurers, and I should just pause there to correct one thing. He doesn't represent all of the insurers, so were the appeal to succeed, there would need to be some complicated maths, but we don't need to be any more concerned with that at this stage. But there are some of the insurers, I think the first layer, one insurer, that he doesn't represent. But in any event, the claim is by each insurer for a share of the recoveries based on the assertion, factual assertion, that the recovery is in respect of an amount that insurer has indemnified. And that means, in our submission, looking at what part of Textainer's loss each policy has indemnified, and then looking at what part of Textainer's loss has been recovered. And it is only if those two coincide, they are the same thing, that is a right for the insurers to be paid part of the recoveries. And again, I should say, just for the avoidance of any doubt, that we don't dispute that if there is a right to the recoveries, there's an equitable lien in favour of it, and various other matters that were raised at first instance. So looking first at the former, what part of the loss each policy has indemnified, this is where it's important to bear in mind, as I said, that the policy pays up. The claim against each insurer, as I've said to my lords and my ladies, is for the aggregate of all losses and damages, including costs and expenses, suffered by the assured resulting from each event insured hereunder. Sorry, from each occurrence insured hereunder. And in our submission, the words insured hereunder, in the context of that provision, must be a reference to the slice insured by that particular policy. So, in the case of the primary policy that the court has in the bundle, the amount insured hereunder is 5 million, and therefore we are looking at a claim for the aggregate of all losses, including all losses suffered, resulting from each occurrence up to the maximum amount of 5 million in excess of 5 million. So that is what the primary policy is indemnified. And as I said, the first policy then is the next 5 million above that 10 and so forth. As to the latter, so the recoveries, so I'm now looking at, have they shown that there's a coincidence between what they've indemnified and the recoveries? And as I've already set out in the reality check, any recovery made only operates to diminish the total loss sustained by Textainer. Put another way, it's in the nature of a programme of insurance providing an indemnity in respect of slices or strata that the recoveries fall to be made allocated top down. And it's precisely that feature of a policy of insurance in strata, or a programme of insurance, that led the Court of Appeal in Napier and then the House of Lords to apply the top-down approach. Napier, as the court has seen, involved 3 layers: the assured's retention, the layer covered by the stop-loss policy, and then the self-insured amount. And I'm not going to go through the figures, my learned friend has taken the court to the figures already. But the relevant loss in our submission, and I'll just look at this briefly and then finish for the day. One has to look at, as my learned friend said, the definition of net underwriting loss, which the court has already, I think, seen. Authorities, tab 6, page 92. Bundle page 92, set out in by Lord Templeman at page 729. And what triggers a claim on the stop-loss policy is the ascertainment of the named net underwriting loss at the end of the 36th month of each underwriting year. What that requires, therefore, is that all the losses and all the credits on the underwriting account are brought into account as at that date. And I would accept that unless and until the 36th month arrives, there's no claim on the insurance. The cause of action doesn't arise till then, because that is the definition of when the loss is assessed. But that doesn't affect the fact that in calculating that loss, what one looks at is the net underwriting position, the liabilities of the name and the credits of the name. And our programme of insurance involves more layers than the 3 layers that were involved in Napier. But in our respectful submission, that doesn't make any difference because certainly, and I'll just give the court three references if I can. Lord Justice Dillon at page 21 of the Court of Appeal report, Lord Justice Staunton at page 22, and Lord Templeman at page 730 of the report, which is pages 72, 73 and 93 of the bundle, respectively, all proceeded on the basis that the result in Napier would have been no different if there had been three insurance companies as opposed to the name, the stop-loss insurers, and then the name. It's the fact that one is operating in strata that matters. And so our programme, like Napier, involves the whole of Textainer's loss suffered as a result of the occurrence. And in Napier, the claim involved the whole of the name's loss suffered as a result of the net underwriting loss assessed at the given date. And in our respectful submission, there's no material difference between our case and Napier when it comes to allocating the recoveries.
So you say there's a claim for a single loss as a result of the occurrence, net of things like recoveries, as you've shown us.
Well, I was going to come on to that,
Okay.
and I will need to develop that tomorrow, but just to outline where I'm going to say, that focusing on whether it is a single loss, or Malone friend I think calls it unitary loss, or a number of losses, is actually looking in our submission in the wrong direction. And the submission I'm going to make is that in one sense, neither Napier nor our programme is a single loss. They both involve a number of losses, which for the purposes of engaging the right to indemnity may need to be crystallised on a particular date. But the phrase I was going to use is that Napier is no more a unitary loss than our case, and our case is no more a multiple loss than Napier. So it is a distinction that in our submission doesn't assist the court to say, is this a unitary loss or not? Because in some senses, they're both equally unitary and both equally multiple losses. But they are materially the same either way. And that is the point I will be developing if it's convenient to the court tomorrow morning. So the next 10 years, grounds for distinguishing me.
All right, thank you very much. We will pause there and resume at 10:30 tomorrow.